afternoon, everyone. My name is Kay Thompson. I am a principal broker here with Best Real Estate, and I want to thank you once again for tuning in to our Agent Focus podcast, the Best Real Estate Company Friday Focus. And if you listened to last week's episode, you know that I had mentioned that we were going to discuss a little bit about agency today. And I know that in our last few episodes, I've taken you guys a little bit over 30 minutes. So I'm really going to do my best to keep today's conversation under 30 minutes. And I think the episode today is extremely important. And so if you guys have any questions about the information that I'm delivering today, please email me, call me, text me, and I'll be happy to answer any questions that you might have about it. So like I said, last week at the end of our episode, I said we were going to talk a little bit about agency this week because I feel like that goes hand in hand with last week's topic. And I just kind of wanted to expound a little bit and give you guys some examples of how overstepping your bounds, the things that you have agreed to do in terms of agency with your client, can result in some really massive consequences when we don't stay within those lines for not just the agent but for our client as well. And so you guys have heard me say in probably almost all of the episodes that are previous to this one that you should look at data, you should look at what's going on in your market, you should be looking at things from a national perspective as well as a local perspective in order to gauge, what practices and tools and things that you want to implement within your business that are going to best align with the legal aspects of our industry, as well as if you're a realtor, your ethical requirements that you swear to uphold when you join the for-profit organization. And sometimes, like I said last week, we get caught up emotionally with our buyers and sellers. We try to do things to make things better for them. It's more of a life situation, a life and death situation. Sometimes for our clients, they make us feel that, and so we feel like we need to just step a little bit further forward to help them to accomplish their goals. And sometimes that little step forward that we take pushes us just beyond the bounds that we need to be in, and then it can cause big issues. So with today's episode, when you guys get this episode, you will also, if you're checking your email, you're also going to get a link to a couple of articles that I think you guys should read. And in case you're not aware of this, on your nar.realtor account, they give us sometimes legal case summaries that we can review. That kind of shows us things that are happening from a legal perspective in terms of real estate in maybe the state that we're working in and living in, or other states. And but some rules, as you know, are national rules, and so they apply to everybody in the country. And we need to make sure that we're not only adhering to our state rules, but to those national rules that they set up for us. And one of the things that I have found myself talking about to agents in the last few years, a lot actually, is about the idea of specific performance. And I like to talk to agents about that because I want them to be aware that that is a legal instrument that the courts can use to push your client to do the thing that they probably have changed their mind about doing. Sometimes, if you're sued for specific performance, you can just be fined by the courts if you're the loser, monetary damages. Sometimes it's a little bit more than that. And so, in my research for us this week for this topic, I was able to find a couple of articles that are fairly recent. One is from February 2024. One is from April 2024. Like I said, these are both in the legal case summary section of your NAR Realtor. One article, the one from February, is titled "Court Requires Completion of Sale After Attempted Void of Purchase Agreement." And then the other one is titled "Broker Liable for Damage Caused by Recommended Roofer." So in the first article, what basically happens is it says a lower courts awarded monetary damage instead of specific performance deemed an abuse of discretion by the state Supreme Court. And so basically what happened is the sellers on April 6th of 2023, the Supreme Court of Wyoming ordered two homeowners to sell their home, overturning a lower court's decision, which only awarded monetary damages to aggrieved buyers after sellers breached a signed purchase agreement. The court found the monetary award essentially rewrote the contract, allowing the homeowners to avoid contractual performance after their desired home became unavailable. So basically, these sellers decided, hey, we're going to put our property on the market that we live in because we want to buy this other property that, better suits our needs for whatever reason. So they put the property on the market in hopes that they were going to get this new property, and for whatever reason, that did not happen. They were not able to move forward with the new property. So they said, hey, we're just not going to sell our house. We're going to stay in it. So that kind of put their buyers in a precarious situation. The buyers had made a formal written offer to the sellers that included additional provisions, specifically allowing the buyers to enforce the agreement and proceed to closing in the event that the sellers defaulted on the agreement. So after brief negotiations, the party agreed to the terms and the buyers deposited $10,000 in earnest money, and the closing was set. And then right before the closing time, or the agreed upon closing date, the sellers informed the buyers that the lot that they were planning to purchase and build a house on was no longer available. So they were going to cancel their contract with the buyers. In response, the buyers refused to cancel, stating that they intended to close the transaction. The sellers responded by indicating a continued intention to cancel the agreement, claiming their own real estate agent failed to insert a home of choice contingency into the contract. The buyers again rejected the sellers' attempts and insisted on closing the transaction, eventually arriving at the closing table with financing in place. The sellers failed to appear to their closing. So the buyers subsequently brought a suit, claiming that the seller's breach entitled them to specific performance remedy and other damages, including attorney's fees. And so specific performance is an equitable remedy which compels a party's performance under the contract. So basically the buyers were saying, you put us in a position where we expected you to carry out the terms of your agreement. You have reneged on your end of the bargain for a reason that is not acceptable to us. The buyer is also saying it's not our fault that your listing agent did not include whatever provision you wanted in terms of being able to back out of the contract in there. And so therefore we want specific performance, which basically what they're saying is they wanted the court to force the sale of this property. And so a lower court said, no, we're not going to force them to sell their house. We're just going to give you this $10,000 earnest money back. The buyers are like, that's not good enough. They put us in a position where we don't have a place to go now. there's other things that weren't considered in that judgment, and so we want to take it to a higher court. They did. They took it to the Supreme Court, and the Wyoming Supreme Court ruled in their favor that they are entitled to the specific performance remedy, and they forced those sellers out of those houses, forced them to sell those houses to the buyer. And so that kind of goes in line with what I was saying last week about making sure that you are reading what you are writing, that you are putting in things that your client actually wants, things that are going to protect them as much as possible in the transaction should something go awry. If you're not clear about how to word something or how to put something in, please contact your brokers. However, your brokers are not practicing attorneys, so we're not going to be giving you a whole book of things to write. If you need something more detailed, more in depth, then we will refer you to an attorney to make sure that things are worded the way that they should be worded. But I wanted to point out that even though the sellers are saying, hey, our agent didn't do this thing for us, the court had no regard for that. Because in essence, the contract is between the buyer and the seller, not the agents involved. This other case about the broker being liable for damage caused by a recommended roofer is very simple. That's another place where I tell people don't step in. I do not hire contractors for my clients. I give them the name and contact information for someone or a few people actually that I think may be able to do a specific job for them, and I have them do the calling and the figuring and all of those things so that they can make the decision about who the best person is to do the work for them. That actually protects you as the agent. And if something goes wrong between that buyer and the seller, then your broker is not the buyer and the seller, but the contractor and the seller, or buyer for that matter. You and a broker are not held liable for that. So in this case, this broker was ordered to pay $143,188.60 in damages because they hired a contractor on behalf of their client to do some work that clearly was not up to standard. So those are some of the, just a little bit of a continuation of what we were talking about last week. And I wanted to just point out a couple of things, a couple of examples that you can refer to and see for yourself about what could happen when you overstep your bounds in terms of agency. And so some of you may be wondering, I'm not exactly sure what the bounds are. What do I owe my client in terms of agency? And so I thought that I would just remind everybody of the LULO acronym that they probably learned about in their real estate course. And so according to what agency is, according to any dictionary or the real estate world for that matter, the word agency is just another term for another way of saying you have a fiduciary duty, which means that you have created a legal relationship of trust and good faith between you and your client. It is the obligation of undivided loyalty. And so when you enter into these agreements with these clients, you have to do specific things in order to show that you are exercising your fiduciary duty and doing it in the proper way. No fiduciary assignment is intended for you to be breaking the law. So if your clients are asking you to do things that are unlawful, you cannot do those things under a fiduciary contract. However, you do owe your client this acronym, and it's called OCAR. And the acronym stands for obedience. So you have to do whatever your client says, whether you like it or not, as long as it's legal. You owe them loyalty, which means you cannot um, be pledging allegiance to another client in to the detriment of the person you have the fiduciary duty with. You owe them the you owe them the fact of disclosure. So if there's anything that you know that is material to them, meaning things that could affect how they decide what to do in a transaction. If you're found not disclosing things that could affect their ability to make a sound decision for themselves, then you are violating the idea of disclosure, that fiduciary duty of disclosure. You also owe them confidentiality, which means you can't be just going to agents and saying, hey, just between me and you, if your client does this, my client will do that. If you don't have expressed permission to share certain things about your client, you are not allowed to do that. You also owe them accounting. So if you're collecting earnest money on their behalf, if you're if which we don't have this situation here, but if you own your own real estate, for example, and you're renting it out, you owe your um, well, maybe that's not a good example, but if you have, like I said, earnest money, you're collecting earnest money and things like that for your clients, and then you're depositing that into an escrow account or making sure that it gets to the closing attorney so that they can deposit it. Those things are parts of accounting, so you owe that to your client to let them know what the standing is of their financing and other type of paperwork. You owe them reasonable care, so you owe your client reasonable care means you can't be careless in what you're doing as you're handling their transaction. You need to be thinking about at all times what's in their best interest. And then you also owe them due diligence. So you have to do your part, research where you need to research for them to help them to make these sound decisions. So you owe them obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care and skill or diligence. That's what OCAR stands for. And if you're not providing all of those things to your client, once, especially after you sign an agreement of representation with them, then you are definitely in violation of your fiduciary duty to them. And one of the things that you can do to keep up with that or to properly explain what your fiduciary duty entails, each one of you should be using the working with the real estate agent or working with the real estate professional or working with the real estate broker form that they're I know they're in our dot loops, and I know they're in all the form packages that we have for the different states. So you want to make sure that if you have trouble explaining what your fiduciary duty to a client is, that you are referring to that document and that you're having your client sign that. And so in conjunction with that, I wanted to point out for my realtors that there are two NAR Code of Ethics articles that you should be always cognizant of um, in your practice of real estate, your real estate business. One is Article 16 of the Code of Ethics, which basically says that realtors shall not engage in any practice or take any action that is inconsistent um, with what their client is asking them to do. It has to be legal, obviously, but you can't do anything that's outside of that written agreement that you have with your client. So, and in our representation agreements, there are little blurbs there that show us, um, again, the things that are within the scope of our fiduciary duties. So make sure that you're not doing that, because not only are you, like I said, violating the real estate legal rules, you are also violating your code of ethics, Article 16. And then also, this one is very important. This is also related to Article 16, and it's something that I see agents do all the time, but they're not aware. Respect the exclusive representation or exclusive brokerage relationship agreements that other realtors have with their clients. So if someone tells you, hey, I have a signed listing agreement, I have a signed buyer's rep agreement, you should stop soliciting that client immediately. You should not be looking to them and saying, hey, I'm going to give you, my card anyway. If that agent, I can do a better job than that agent. Like, that is a violation of your ethics. And it just goes against the golden rule. You don't want someone coming, behind you after you've done all this work to, secure a client and undermine, the relationship that you're building on with your client. So, um, even in that case, we can be punished. I mean, if it's found out that you interfere with someone's agency agreement, another agent's agency agreement, they can take different steps. Like, their broker may decide, hey, well, we're owed a part of the commission you earned. So they can, take your brokerage to civil court, your broker, and, force payment of that, which is something we definitely don't want. And if you're caught doing that, even though we're in the Mid-South, and technically the Mid-South encompasses 3 states, we are very closed, tight-knit community, us real estate professionals, and eventually people get to knowing people, who they are, even if they just hear their names. And so, your reputation can easily precede you in this market with these professionals. So you don't want to get into the habit of, um, continuing to have conversations with people when they already have a signed agreement in place. And you don't want a reputation for doing that either, because even though they're not supposed to, sometimes, people can be shunned for activities that, a group of people may deem unacceptable. And so, with that being said, like I said before, if you have any other questions, or if you have any specific things about agency that you want more information on, I urge you, if you don't have access to it already, to go to our Best Real Estate Company Agent Resources folder. And I sent that out on an email link a few times in the past. I'll send it out one extra time here, but you can look at the state information, and in every state that we have licensing, there is information in there from the state regarding agency, what it is, and how you should operate to keep yourself from having a liable situation, or a situation where you're liable for something that you didn't intend. And if you can't find the specific answer that you're looking for there, please, please, please reach out to us, call the office, and ask for a broker for that respective state, and we'll be able to assist you. And if we don't have the answer, we know how to go find it. So again, with that being said, I'd like to thank you so, so much for joining us today. And I hope that you take care of yourselves and that you have an awesome weekend. Bye now.